United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter, who dissented in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout, and while there they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but now, what do you do with that?
I'd say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I'd make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme that like you can't be doing this because you can't make and we all agree, or it's obvious, that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. And again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we've decided is the citizenship status of the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what they said, but your test is the domicile of the parents, and that would be the test you'd have us apply today, right?
Yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so on our test, yeah. If they're lawfully domiciled here.
Okay.
I'm not sure. I have to think that through, but that's my reaction.
I'll take the yes. That's all right. And then I just want to ask you quickly about the INA, adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation. I give 2 reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute, and nobody thinks that those ossify, are limited to the precedent, this court's precedents at the time they are enacted. Everyone thinks that phrase, due process, incorporates, the developing law of due process and minimum context and so forth, including from this court. So we think that's the best analogy when you're looking at the constitutional phrase itself and you take it out of a freighted context. The natural interpretation is to say this reflects the objective meaning of the Constitution, and the objective meaning of the Constitution is its original public meaning in 1866 and 1868.
Do you see any notable counterpoints to that argument?
I'm sure there are arguments on the other side. We addressed them in their brief.
So you're really, at the end of the day, then, this is a straight up constitutional ruling you want from this court, win, lose, or draw?
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling if the court's going to do that on a statutory basis and a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option, is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Gorsuch asked the Trump administration's Solicitor General a simple question. Do you think Native Americans today are birthright citizens under your test? The Hill reported that Solicitor General Sauer initially answered, "I think so," then reversed himself when pressed, saying the clear understanding from congressional debates is that the children of tribal Indians are not birthright citizens. Gorsuch's response was 4 words: "I'll take the yes." Rep. Teresa Leger Fernandez put it more bluntly, saying, "Imagine going before the Supreme Court to attack birthright citizenship and being unable to say Native Americans are American citizens. This was never about the Constitution. It's about exclusion." Trump signed the executive order on January 20th, 2025, the day he took office, titling it, "Protecting the Meaning and Value of American Citizenship." SCOTUS blog reported that every single federal court that reviewed the order struck it down before it reached the Supreme Court, a track record that speaks for itself. Sauer argued that the Citizenship Clause of the 14th Amendment was intended only for newly freed enslaved people and their children. When justices pressed him on birth tourism, asking how widespread it actually is, Sauer acknowledged that no one knows for sure, which raises the question of whether this executive order was ever based on evidence or simply on politics. The case before the Supreme Court is titled Trump versus Barbara. CBS News reported that Chief Justice Roberts told Sauer his examples were very quirky. Justice Kagan said, "The text of the clause does not support you." And Justice Barrett asked the practical question that undermines the entire theory. What if you don't know who the parents are? Justice Jackson asked how anyone would even determine whether a newborn is a citizen under the administration's proposed rule. The ACLU's legal director warned that accepting the government's theory would render swaths of American laws senseless and could potentially strip citizenship from millions of people already living in this country. The Trump administration's legal argument rests on an 1884 Supreme Court case called Elk v. Wilkins, which denied citizenship to a Native American man named John Elk because he was born on a reservation. NBC News reported that Elk, believed to be a member of the Winnebago tribe, was denied voter registration in 1880 simply because he was Native American, and the administration is now using that case to deny citizenship to a new generation. Leonard Feinday of the National Congress of American Indians called the administration's reliance on Elk versus Wilkins a misreading and a misunderstanding. Monty Mills of the University of Washington agreed, saying the approach betrays a lack of understanding and awareness. And NBC noted that Justice Horace Gray, who authored both the Elk decision and the later Wong Kim Ark ruling, himself distinguished the two cases as applying to entirely different circumstances. On June 2, 1924, President Calvin Coolidge signed the Indian Citizenship Act, finally granting citizenship to all Native Americans born in the United States. The National Constitution Center noted that at the time, 125,000 out of an estimated 300,000 Native Americans were still not citizens, meaning the 14th Amendment had excluded them from its protections for more than 50 years. Even after the 1924 Act, 7 states still refused to grant Native Americans voting rights as late as 1938. That is the history the Trump administration is invoking, a legal framework that was used to exclude people born on this land from the rights of citizenship for generations. Slate reported that Trump made a notable appearance at oral arguments sitting in the courtroom during the Birthright citizenship hearing. His presence appeared designed to pressure the justices, but the strategy produced the opposite effect, as Gorsuch's pointed questioning demonstrated that even a conservative justice appointed by Trump himself found the administration's legal theory deeply troubling. After just over 2 hours of oral arguments, a majority of the Supreme Court appeared likely to strike down the executive order. PBS reported that UVA law professor Amanda Frost explained the framers of the 14th Amendment intended only narrow exceptions, primarily for children of diplomats and members of sovereign tribal nations at the time, not for the sweeping exclusion the administration proposed. The 14th Amendment states plainly, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States." The NAACP Legal Defense Fund noted that the executive order specifically targets children born when the mother was unlawfully present and the father was not a citizen or lawful permanent resident, a rule that would only apply to births on or after February 19, 2025. Federal courts have repeatedly blocked the order, finding it violates the Constitution over a century of Supreme Court precedent and long-standing federal statute. A ruling from the Supreme Court is expected by late June or early July 2026, and the question is whether 5 justices will reaffirm what the Constitution has said since 1868 or rewrite it. The irony of this case is difficult to overstate. The government cited a ruling that denied citizenship to Native Americans in order to deny citizenship to a new group of children born on American soil. And when a justice asked whether that same logic would strip citizenship from Native Americans today, the government's lawyer could not give a straight answer. America spent 56 years denying birthright citizenship to the first people who lived on this land, and now the same legal reasoning is being revived to exclude the children of immigrants. Subscribe, because the 14th Amendment was written to end exactly this kind of exclusion, and whether it still does is about to be decided.